to ask one question myself, which I will. In your paper, you contrast rules and on one hand and principles and standards on the other, and Tom Merrill referred to that. But the rules are very, very narrow. Every state has 2 senators. The last time I looked, nobody was trying to take away one or both senators. The president has 4 years. The last time I looked, no one was trying to make it 6 years or 3. And so these rules are so narrow, nobody fights about them. Nobody litigates them. The only provisions of the Constitution that people care about and litigate are what you call standards or principles. And then you say on page 6 of your paper, the last little paragraph, choosing a standard or principle normally means that adopters are delegating the task of application to later generations. So what you're saying, in effect, is that everything in the Constitution, every clause in the Constitution worth fighting about, is delegated to later generations. Now that's a strange position for an originalist to take, isn't it?
No. Not at all. The whole point of setting down things in rules is precisely to avoid fighting about them later on. Imagine that there was imagine that what happened was that the length of the president's term was stated in terms of a standard, as shall be reasonably necessary to the public safety and interest. This would be a very dangerous clause to put in the Constitution for obvious reasons. So if you look at the things that are hardwired, and you think about it not from a lawyer's eye, but from the standpoint of political theory or political prudence, you can see why certain things are basically hardwired, why the framework is created. They're trying to set politics in motion. What it means to set politics in motion is to set controversy in motion. Politics is about disagreement. Politics is not about consensus. Politics is about people fighting, disagreeing, and then creating a community over time through struggle. A good constitution makes that possible. This is a feature, not a bug, of a well-constructed constitution. And every constitution I've ever read after the United States has this panoply of rules, standards, and principles. And often, when they misfire or they break down, it's because of a bad judgment about what you want to delegate. So I don't want to give too many comparative examples, but I'll just leave it there.
Okay, the first person I recognized was Professor Larry Alexander.
Yeah, Jack, there's, I'm in, I would say, almost total agreement with this chapter, and I want to say something about the taxonomy that Tom gave, because I think it's so. Here's, I think it in some ways it conflates different things. So if we have the faithful agent model, which in which you have the rules that the interpreter must follow, and then standards, which the interpreter also must follow, but standards essentially delegate to the future interpreter. The interpretation stops when you discover it's a standard. After that, you then read you then attempt to apply the standard, which is a different matter, and I'm going to say something about that in a second. So Jack and I are in the faithful agent camp. Then you gave the integrative model, which was Dworkin is the foremost example of it. Now, I would say the integrative model is not a model of interpretation. It's a model about, because you notice you have to integrate the various its, the things to integrate. And those things have to have some sort of solidity to them. There has to be something there. And so if it's a rule, like the 2-senator rule, and you're trying to integrate it, you're not going to interpret that rule by integration. You're going to interpret that rule to require 2 senators, and then you're going to integrate that with other things. And so I would distinguish between the interpretation and the law. I think the integrative theorist makes the distinction between what you're interpreting and what the law is. And for it to work in the law is what you get out of the integration of the various parts. But the parts themselves have to have some, there has to be a there. It's got to be what he calls pre-interpretive matter. The welfarist, I think, on your rendition of Posner, it can be read as a faithful agent model in which you just, if the statute contains within it some sort of standard, then you can apply welfarism within the interstices. That's not different from the faithful agent model. I mean, a true welfarist would the statute can say X or the statute can say not X, and I'm going to apply my welfare theory in the same way in both cases. Now that would be essentially just unmitigated welfarism with statutes just being noise in the background. And so I think the real here's where I think real differences might appear between Jack's view and my view, and that goes back to first, is this term actually a standard? Because I think one can jump too quickly from language where you don't have a clear denotation to viewing it as a standard. But the other thing is that I think that if it is truly a standard and a delegation, then I think the interpreter is perforce going to have to apply his own moral theory. And so if he's, for example, if he's just a straight utilitarian, if he thinks that's the best theory, then whether it is equal protection, if that's a standard, or freedom of expression, if that's a standard, he's going to still apply this. It's going to be the same thing, because in his theory doesn't have those joints in it. There is no principle of freedom of expression.
Why don't we let Professor Walker respond to some of the points you made?
Yeah.
Well, actually, most of these were directed at Tom. The last one was directed at me.
I would respond. Okay. Go ahead.
Yeah. The last thing is a really interesting point, which is who's going to be doing the articulation in the future? My assumption is that there will be many different people who will be in politics contesting over this, and they will have a variety of different moral theories. And for some, they won't even understand what they're doing in terms of, I'm trying to articulate a moral theory and follow it. They will have a particular set of what they believe to be political goals that they're trying to achieve. And they won't even rationalize them in terms of what a philosopher would consider a moral theory. And what they'll do is they'll draw upon the previous practices, previous political rhetoric by others, and they'll try to show that this is in fact the way forward. So to just take the example of gay marriage, what happens is people will draw analogies to the civil rights movement. They'll claim Martin Luther King. They'll make all sorts of analogies to history. They'll do, in other words, what ordinary people do when they're making moral claims. Now, what I want to know is what the relationship is between that, my prediction of how the practice will go forward, how the rhetoric will go forward, and the concern that you're raising about the flatness of some moral theories in articulating standards or principles. That's really the nub of the question. What follows from the clash of those two facts?
Tom, you want to add anything?
Well, on what is interpretation, I maybe in some kind of linguistic or philosophical sense, you can say that the only thing that's true interpretation is when you are looking at a text and trying to ascertain the meaning of that text in light of some understanding of the intentions or the purposes of the author of the text. But as a social practice, legal interpretation, there's no question, but the range of considerations is broader. Statutory interpretation, for example, the courts refer to various cans of interpretation, grammatical and substantive. They refer to other statutory provisions that shed light, structural considerations, whole act considerations, administrative agency interpretations, as well as past precedents by courts interpreting the language and how they came out, what their reasoning was. And so I think as a legal practice, I'm fairly comfortable in saying that the practice of interpretation is understood in certain statutory context includes this wider range of the sources of authority than simply the text and some construction of the authorial intent. One thing I didn't get to say, which I will now add into my 13 minutes plus, is that I'm a conservative. I'm sort of scared by Jack's theory in a way because if you move quickly from the principle or the idea of a broad principle to a delegation to whatever the current generation is, and that's your whole theory, and then the content of the Constitution is going to be determined by social movements, I guess, which we don't even know what they're going to be like. To me, that's kind of a creepy, scary scenario. The integrationist approach, and either the Dworkinian version or my preferred Burkean version, is much more kind of constrained in the sense that you can at least predict that whatever happens is going to be something that has to be reconciled with what's gone in the past. And so that puts a brake on future possibilities. If you're kind of a pessimist about the future and you're worried about the bad that might happen as opposed to the good that might happen, maybe that's reassuring. And classic originalism, or even originalism that looks to the purposes of the enacted body as opposed to this theory of Jack's about attributing purposes as if a purpose is, I think involves more constraint because you can have some sense about the purposes of the actual enactors of the Constitution. You may feel comfortable that you can live with those, but the as-if purposes that are attributed to the text by future generations of judges which are put in office by social movements, the nature of which we can't even imagine, is a little more unsettling.
Can I just say a little bit on that? Because he touched on a really important theme that I wish we had gotten out in the main thing. So the end of the chapter talks about the role of faith as a key element in a constitutional scheme. And what Tom has just done is he has shown you in a really powerful way what's really at stake in debates, a lot of debates over constitutional theory. That is, how much trust do you have in later generations to carry out the plan for politics in a way that's going to be hopeful? And how much lack of faith do you have in their ability to conduct politics in a decent way? If you don't have faith in them, then you should construct the plan in such a way as to constrain their range of motion. And if you do have some degree of faith in their ability to carry out politics, then you give them greater delegation because they have to meet with emergencies. They have to deal with emergencies and unforeseen events. And you're not all-knowing and you're not, right? And within a sort of Burkean model, it's not just that the Burkeans are pessimists. The Burkeans go both ways. A Burkean could say, just as later generations aren't omniscient, this generation isn't omniscient. Because this generation isn't omniscient, it needs to have some degree of faith in the ability of decent people in the future to carry out politics. So because I am limited in my knowledge, I have to delegate. The other version of Burkeanism is I know what people are like. People think they know, they make big claims, but often the big claims fall, they fall flat on their face. We have to create certain kinds of institutions that prevent people from running roughshod over liberties, for example, or destroying the possibility of a secure nation. That is, I think, at the heart of
I've got it. Okay. I got people waiting on that. Klaus. I've got to go back to you when I can.
So I just want to take up the generational point. We're not really handing this task of constitutional exposition to generations, though, are we? We're handing them to tiny little groups of oracles. And we don't see, do we, among any of the non-originalist theorists, much enthusiasm for the thought that maybe there's a question whether the words of the oracles, the words of the Supreme Court, ought to be read in an originalist fashion. Maybe they should be read in a non-originalist fashion. Outside of Stephen Reinhardt, we don't have many people advocating that. You don't get many lower courts saying, oh, should we read these words of the Supreme Court according to their original public meaning? And Cooper v. Aaron necessarily implies you've got to read us according to our original public meaning. You segregationist government actors in the South are not free to read our words according to your vision of political perfection. Right? You must read them according to the original public meaning of 1953 English, this is what we're saying. Right? Or perhaps they're our intention if we're intentions, one or the other. But either way, you get to the same result. Right?
So I disagree with two parts of that. The first is I disagree that the delegation that a constitutional system provides a delegation to a small number of oracles. The second thing I disagree with is that, in fact, what future Supreme Courts demand of lower courts is that they read earlier Supreme Court decisions in any particular way. Because that's a question about how you manage a system of superior and inferior courts. And that's orthogonal to claims about structures and interpretation, philosophical ideas. It's just a completely different set of questions. But the more important question is the first one. This is my political science hat. Keith can correct me. He's written, I think, the great work in this field. But my general sense is that the Supreme Court of the United States, although it's a player in national politics, is not the most dominant player in national politics. And that the Supreme Court, to a very large degree, is involved in the maintenance of the political regime, which is created by political actors, including representatives of the various branches, and also civil society organizations, which include now increasingly what we would call social movements and political movements. But if you want to understand the engine of constitutional change, the Supreme Court is a player, but it's really not the most important player. And I can give you chapter and verse on almost any important moment in constitutional change, and I can show you that although you think it's the oracles talking, the oracles are actually hand puppets. That's too extreme a view, but I'm just trying to do it to back the obvious view that they're oracles. They're not hand puppets. What they are is they're one power center in a variety of different power centers. But the view that too many people think, and the reason why they're afraid, is because they think what you're doing is you're handing it off to a relatively small number of human beings. That's not how this political system works. It's not how it's ever worked. It's just a misunderstanding of the nature of the machine.
All right, so
Yeah, so question is about what parts of the project are driven by some normative commitment or theory, and what parts are positive theory. And of course, you have another option you can interpret. And so, I think that the folk understanding of Jack Balkin is that he's got this normative theory, right, going with respect to we're bound by a principle of fidelity when we interpret the text to the public meaning. But then he has this other theory, this theory of constitutional change, right? And as you discussed the theory today, it sounds like your view about construction, right, is that it's not driven, it operates within the limits of fidelity, right? But what happens within those limits, it's a matter of flux driven by the political process, right? So on that picture, the theory has a normative principle of fidelity and then a positive theory of constitutional flux. So that would be one possible reading of you, right? Another reading would be that the fidelity principle is actually not normative at all. That when you, and there were things you said, right, in the remarks you made at the podium that sounded like that the principle of fidelity is actually descriptive. It's describing something that happens within our practice, that we don't deviate from the rules, the linguistic meaning of the Constitution. That provides a framework, but that it could change, right? It could change tomorrow if through some odd happenstance of events, you know, we started engaging in numerologist style readings of the Constitution. Extraordinarily unlikely. But then you say you're against that, right? So that suggests that, in fact, there's some normative theory operating here. So if there is a normative theory, then the question is your account of construction or of the flux or of constitutional politics, right, does that have a normative foundation? That is, do you think that not just that this is the way it is, but this is the way it should be? Do you believe in some normative limits on what should occur in the construction zone that ought to be a shared part of that practice do you have a normative theory of constitutional politics, or is it all positive? So that's the question. Where's the normative part? Where's the positive part? And
unfortunately, it's going to be interpreted. You know
Yeah.
the answer is going to be interpreted. So start from the assumption that what you want to do is you realize that we're engaged in a certain kind of politics. And this kind of politics solves problems through the use of a written constitution. There have been political regimes before us that didn't use written constitutions. No doubt someday there will be regimes after us that don't use written constitutions either. But at a certain period in human history, this is how we're trying to solve certain problems of politics. We're trying to create decent lives for people. We're trying to prevent abuses of power. We're trying to do the things that the frameworks of politics are trying to do. We do that through the use of a written constitution. What are the fair rules of play in using a written text for the purpose of creating a framework for politics? Now that is both a descriptive claim, because it's grounded in a certain set of understanding of historical predicament, and it's a normative claim, because you're trying to make a claim of what it's fair to do. So it's both at the same time. As a participant, not merely an analyst, but a participant in the practice of politics, as a person who's sitting in now, I have normative views about what's a fair move and not a fair move in using texts. It is my belief it is unfair to count numerological equivalents of letters in the word equal protection and then use that to show that it's equivalent to gay rights. That is not an appropriate or fair move. And if you want to have a discussion about why I think that's not a fair move, I'd be happy to have it. You can probably guess what my arguments will be. But in any case, that's a normative claim. But it's also grounded against my sense of what it would be fair to require of other people, which also is an understanding of the historical predicament in which I am. Suppose a group of people start making gematria-style arguments. I want to tell you that I will be out there on the ramparts calling these people insane, telling them they don't understand fidelity, telling them they don't understand how to use a written constitution, even though the anthropological part of me knows that there have been moments in human history when people accept these as perfectly permissible. But that doesn't matter, because I'm here right now and I'm trying to be fair to other people in politics. That's how you do it. Is that helpful to understanding the claim?
well, yeah, certainly. Once you bite the interpretivist bullet, then it's clear which way you're going. But then I just would say then that there's a host of problems with interpretivism, right? That and obviously we only have one chapter of the book, right? And these are problems, at a higher level of abstraction, philosophical problems with the view that you can mix the positive and normative in this way. And I just, I don't. It's really not. Since it's not in the chapter.
Do it, I've seen it done.
Maybe you see people try to do it, and the question is whether or not it works. And I don't think we should discuss this any further here, because it obviously would involve parts that are not before us now. And I don't know but I'm just curious. Let me just ask one tiny follow-up. Is there a part of the book that really addresses the objections to the interpretivist framework?
No, other than just showing you how to do it. That is because it's ultimately my view that those debates can only be settled in practice.
Okay, Steve Smith.
Okay.
Sorry.
Yeah, well, actually, a whole bunch of things. One thing I'll just note parenthetically in case it comes up, because yesterday it was predicted that it would, and I was told that something about principles, and Larry had raised the question, what do you even mean? And you said we talk about that tomorrow, but the conversation hasn't gone that way, so unfortunately, I think so. But I was really interested in the conversation that you and Tom and Laurie had, and I just want to see if I can go a bit farther on that. So you said, I think in response to Tom, that the Burkean approach can, people can be pessimists, or they can be more optimists, and you're maybe on the more optimist side. And then Laurie raised a question, are you optimist? And I was trying to think, what sort of faith? I think you put it in terms of faith in future generations, their virtue and wisdom.
Right.
So what sort of faith in future generations and their virtue and wisdom would lead you to adopt the strategy of a written constitution of the kind that we have? I think it was born in concern about, not faith in future generations, and put it this way, that if you really have faith in future generations and their virtue and wisdom, it's not clear why you would want to limit them with, a fairly constraining written constitution. I mean, let them do their own thing. Why would you have any confidence that you would even be posing the right questions for them or the right constraints for them to interpret? If they're going to be wise and virtuous, let them make their own way. Now, that would, so it creates the suspicion, I think Laurie expressed, that the kind of attitude that would lead to this strategy would be one, if you had faith in the wisdom and virtue of future elites, but not of the people generally. And so you want to create a mechanism in which those people in whom you have faith will be able to use this thing that you've created to constrain the people generally. But in your response to that, to Laurie, I think, you indicated that isn't your view, and you don't think that's how it works, and so forth. It's a much more participatory sort of full, thing, which I think then, to me, would just lead back to the question: well, then why would you adopt this strategy of the written constitution if what you want is a broad politics with social movements and everybody, let them go at it. Why try and focus them on questions like what does equal protection mean, or what does due process mean, and so forth? It just seems like a very odd way to carry out that sort of project if that is your faith and your vision. So.
There are two things you run together. Laurie's question, as I understood it, was not a claim about elites versus the masses. It was a claim about judges versus other political branches. Okay, that's the first thing I think might be a confusion. Laurie, as I understood it, was asking, isn't delegation to future generations a delegation to a small elite set of judicial actors about the meaning of the text? I said, no, it is not. It is actually, they are a part of a larger scheme of political actors. Political actors, however, are structured into political elites and their constituents and other actors who are in civil society or members of elites. And the ways in which these people interact is very complicated and is not easily understood in an on-off story about elites or masses. And in fact, their relationship has changed considerably through American history. It is, and if you had any sense about that relationship, as I think people did, you would realize that you couldn't design a system that would only be for elites, or only because you wouldn't know how the construction of the people would look over time either. So in some sense, these questions you're raising are kind of orthogonal. The other question is, why would you have a written constitution if you believed in the trust and virtue of the people? Isn't it clear that the framers are very pessimistic people? That's why they chose a written constitution. And I think that also is a too black and white understanding of why people choose political constitutions. The framers are a complicated group. They're Enlightenment folks, so they clearly believe in progress. They clearly believe in the use of reason to make things better for human beings, right? But they're also students of history. They have studied the history of republics from Greece, democracy, through Roman republics to the present. And the one thing they know, at least Aristotle taught them, and they also learned it through the Roman Republic, is that republics inherently have features that lead to decay and rise of demagogues. And no matter how wise and virtuous individuals are, these structural features arise. And for that reason, to realize the possibility of the use of reason in politics, which I think is one of their goals, you have to create a framework that makes it possible over time for reason to win out and to make it possible to have a decent form of politics. At any moment, because at any moment forces are always aligned that can lead to demagoguery and destruction of republics. So both of these things are going on at the same time. So I don't classify them as either optimists or pessimists. I classify them as realists. And I think of them as using words, written words, as a way of creating a framework in which a decent politics could go forward. But they understood at that time, I mean, I'm not making this stuff up, maybe you have to back me out, that they understood the limitations of language. They understood that there's only a certain number of things you can do with language, written language, and that a lot of what's going to have to depend on practices going forward. And a lot of it's just going to have to deal with faith of the possibility that future generations will be sufficiently decent to keep the thing going and not degenerate. And you can see language of faith in the discussion of the founding. You can see discussions of human frailty in the time of the founding. And you can see meditations on the imperfections of language. Professor Fleming.
I think this is a terrific project. I think it's absolutely persuasive. My question is, what is the difference between your method of text and principle and the Dworkinian moral reading of the Constitution? Like Dworkin, you put an emphasis upon the Constitution as a scheme of abstract principles and commitments, and you distinguish between those principles and the concrete expected applications of them. That's a distinction that Dworkin has made in many contexts over the years. You articulate the project of constitutional interpretation as one of fidelity with those abstract commitments. That's what Dworkin has characterized the project of constitutional interpretation as being over the last 30 years of his work. You conceive the struggle in constitutional interpretation as a battle among competing accounts of the best understanding of our commitments. That's what Dworkin says constitutional interpretation is all about. Now, in my paper, I suggest that Dworkin's moral reading is a big tent that can embrace the work of abstract originalists like you. People like you are doing fit work in service of the moral reading. And I take, I relish Tom's suggestion that if anything, your project may be less constraining than the Dworkinian project. But that's the only difference I see between your project and Dworkin's project of a moral reading. So how do you describe it?
This is going to, I don't mean to sound churlish, because I'm not. But listen to the conversation that I had with Tom, with Laurie, and then with Steve. And think about the themes of that conversation. They were about human frailty, human perfectibility, they were about institutional structure, they were about the course of history, they were about how you make politics work, the messiness of politics, and these kinds of features of the human predicament. That's really what all this conversation has been about. I rarely see any of that in Ronald's work. I mean, I'm not being churlish to you, I'm being churlish to Ronald's work. I rarely see him grapple with those features of politics, and instead it seems to be a debate about the best moral theory. It's true that there's connection, but that seems to me the biggest difference. Now, on a very limited theoretical level, it has never been clear to me what a principle is, what includes and what is not included for Dworkin. When I think about principles in the context of this project, some of them look like moral principles, but some of them look like principles of political administration. Some of them look like, so for example, I was thinking about Tom's paper, hard to get into war, easy to get out, right? That's a principle, or it's a rule of thumb, who knows what it is, but it's not, it doesn't look like a Dworkinian principle. Here's another principle in the chapter I'm writing on commerce, which is a principle that the federal government has the power to legislate in cases where the states are severally incompetent or where national goals will be interfered with by the disharmony between states. That looks like a political principle of administration to me. Is it a Dworkinian principle? I have no idea. Part of this is because most of Dworkin's writing is not about the messy details of structural politics, but rather about gay rights, groundwork, board of education, and freedom of speech. So it's possible that I'm just laboring in the vineyards for Ronnie Dworkin, or it's possible that my project has interesting divergences. I will leave that to you to decide.
Back to you, Larry. Alexander.
Yeah, I want to just get back in on the dialogue you had with Laurie and Steve, because this is an important interpretive point. So you have a clause in the Constitution, let's say equal protection or something that people are quick to jump on and say, well, that's a standard, or that's a principle, and it's a delegation to future generations to work out their best understanding of what this is. Now, So, but notice that when a case is litigated to the Supreme Court, and the Supreme Court puts its imprimatur on one understanding of that, that understanding trumps politics then. I mean, it basically, if you really wanted to delegate to the populace, you would just leave the populace free to do politics. So the question is, would the framers? So it's a question of how you understand.
By the way, that's an inaccurate statement of how the system works. But if you want to go forward with that, that's fine.
Well, I'm gonna stick with it at the moment here. You can. So normally, faith in future generations is evinced by leaving future generations free to determine through politics or whatever how things will be. When the Supreme Court gets into the act, it puts a brake on some sort. It redirects politics and puts a brake on certain kinds of politics. And so the question then is, can we infer that that's what the framers intended? That they intended to delegate ultimately to the Supreme Court that authority to put its gloss on that principle. Its gloss may it may not be original with it. It may have come through its understanding of certain parties in the process. But nonetheless, it's going to be a partisan gloss, and it's going to be partisan gloss at the level of where the supremacy clause it trumps other political understandings. So the question is, one, do you interpret the framers to have done that when they put that clause in there?
Yeah. First, understand that the Supreme Court does not work the way you think it works. That generations of political science have suggested that this is not the way it works. I have no reason to think that the next generation of political scientists will tell the previous generation they were wrong about it. This is just not how it works. The Supreme Court has neither the first word nor the last word in the meaning of the Constitution. It has neither the first word nor the last meaning on the interpretation or enforcement of constitutional values.
This is a question of what the framers would have anticipated.
I understand that. I just want to get this out because when I talk to people who aren't political scientists or aren't informed by that reading, they start a completely different vision of how a political system works. And I just want you to understand this is not how it works. Now, what we actually have is a much more complicated system in which the Supreme Court acts as a temporary break on how constitutional norms develop over time, but not a permanent break, and that political mobilization and subsequent appointments, which are part of the political process, actually are the engine in which you, what's the right word for them? There's a word for it's not a navigator or delegator. What's the right word for it? Anyway, it's the control mechanism for doing it, which is a yeah, well, who knows? But in any case, yeah. Anyway, it's a conservative in the old sense, restraining on new interpretations, but not the last word. It's just not. It doesn't work that way. The framers had no idea that the process of judicial review would develop in the way it has. I have found no evidence that they imagined anything like the way in which the current Supreme Court works or the federal judiciary works. First of all, they didn't know there was going to be a tier-rated federal judiciary in the forum. That was left open. That they had no idea that most of the populace was going to be enfranchised eventually. They had no idea what the future of slavery was. They had no idea political parties would form. All these are the ingredients of the way in which the system currently works. They hadn't a clue. And they also didn't have a clue that there would be this continuous engine of constitutional litigation called the 14th Amendment, which by taking rights in the Constitution, federal Constitution, and applying to the states, would multiply by whatever number of states happen to be in the Union at the time, the number of possibilities for people to raise judicial claims about the meaning of constitutional principles. Right? So that in the system they imagine that there's only one federal government, and most of what the Supreme Court is doing is construing possible transgressions of the Constitution by the federal government. As soon as you have the Civil War, and you create the 14th Amendment, and the courts start hearing claims that every little hamlet and locality, mayor, local school board that does something that somebody can complain about as violating a constitutional principle can be taken to the federal system, which is now expanded and grown because of post-Civil War statutes, jurisdiction. Nobody in the framing had any idea that would happen. Completely, no, zip. The question, of course, is how, under these changed conditions, right, do you work the plan forward? And there's no obvious way, single obvious way to work it forward, because that was completely unintended. In the same way, our current national, this is your paper, really, current national security system is based on a complete change in military technology and organization and politics, which could not have been comprehended at all by the framers. Our problem today is how do we make our system go forward with all those changes?
All right, Tom.
I just wanted
the
to
last word.
pick up on the theme that Jim's comments raised about Dworkinianism versus Balkanization, whatever. I think there's a big difference, that's an important one, between what I call integrative theories and any type of faithful agent theory, including Jack's, which is that the faithful agent theories tend to view the process of interpretation as a series of direct confrontations between the current interpreter and the original enactor, in which each generation of interpreters has this direct existential confrontation with the text and its meaning, and then devises whatever conclusions that they reach. And I think the whole framing of faithful agent thinking sort of inclines one in that direction. I don't think that's a very good picture of the way the process of constitutional interpretation actually works. I think that the faithful agent model causes everything that happened between then and now to drop out of the analysis. And in fact, the way the process works is that everything that happened in between is relevant to the analysis. And that the courts and the advocates and everyone else are grappling not only with their reconceptualization, in fact, they rarely grapple with a reconceptualization of what the founding generation actually intended. That's extremely unusual. What they're doing is they're reinterpreting everything that happened between then and now in light of some type of integrative theory, which has creative aspects. It's reformulating the plan and so forth, as Jack says, but it's doing so in a way which is constrained by many more data points than the faithful agent theory seems to acknowledge. So in that sense, I think integrative theories are always inherently more constraining than our faithful agent theories.
Okay, I think that we've got a minute and a half left. Can you limit it to a minute and a half, Larry?
No, it's not mine, not me.
All right. Anybody?
Michael,
Make it a microphone.
Great. Yeah, I have 2 points. One point which goes back to yesterday, Jack, is when you talk about the framers, you stop in 1789, 1790. One of my...
Shouldn't do that.
No,
that wouldn't be prudent.
The other question I have is, when you think of a principle like equal protection, is there a central core which is more rule-like? Or is it all equally up for grabs?
If you were, Rubenfeld's tried to come up with a way of creating a core, and he may be right. The problem is that Rubenfeld's theory of the core is based on a strong distinction between rights and powers that may not be an adequate assumption. That he's trying to develop a theory like that. I tend to believe that if you look at the way in which people rely on past readings as a way of going forward, you get the effect of a core that's preserved over time, even though in fact there's no hard and fast rule that the core has to be preserved over time.
Okay, I now pronounce that the third session is over.